The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. This morning, 4 cases will be submitted. Those cases are State of Iowa versus Darrell Shears Jr., Susan E. Cox and Edward Cox versus Iowa Department of Human Services, State of Iowa versus Quentin McMurray, and State of Iowa versus Tyson Ruth. The last 2 cases are now submitted to the court and will proceed to hear the arguments in State versus Shears. Ms. Stewart.
May it please the court, counsel, my name is Ashley Stewart and I represent Darrell Shears Jr. Mr. Shears is not responsible for damages done to the Davenport police vehicles because it was outside the scope of his liability. Under Iowa Code Section 910.15, a victim is defined as a person, or in this case, a government entity, who suffered pecuniary damages as a result of the offender's criminal conduct. Also under Iowa Code 910.2, in order to award restitution, this court must find a causal connection between the harm suffered and the offender's criminal conduct. Under Iowa Code 910.13, damages are recoverable if under a civil action if the harm can be recovered under a civil action. Restitution is then determined under civil tort law. This court has said in Thompson v. Kaczynski that civil restitution that can be recovered under a civil action should be analyzed under Restatement Third of Torts.
Does Thompson really apply to this case? This would be an intentional tort, wouldn't it?
I don't believe so.
Driving, eluding an officer would not be an intentional tort?
No. Eluding doesn't have a victim in this, which is why it should be analyzed under scope of liability, because we should really look at the causation, which is what Thompson v. Kaczynski talks about. It talks about scope of liability in a causation rubric.
But that only applies to a negligence action. There's another restatement section that applies to a intentional action or a reckless action. And I don't see this eluding to be a negligent action on the part of your client.
Well, Your Honor, I respectfully disagree. I do believe that this should be analyzed under a negligence analysis.
But why is eluding negligence? Explain that to me.
Well, we know that with eluding, the risk that's assumed while eluding is driving erratically, disobeying rules of the road. All of those are negligence torts. And so I think it should be analyzed under a negligence causation.
Well, even if you did, even accepting that, reasonably foreseeable, if someone engages in eluding a high-speed chase, to put it in vernacular, isn't it reasonable to expect, A, that police will chase you, and B, that there can be accidents to squad cars along the way?
Well, that's just it. Under scope of liability, you don't have to focus on foreseeability. You just have to look at what makes the offender's conduct tortious, in this case the eluding, and then look at what harm would have what harm resulted from that specific risk.
You're right. You're right about Thompson and foreseeability, but even characterizing it as outside the scope of risk. Isn't it within the scope of risk that if you elude, run away? I mean, the crime itself requires that there be a peace officer on the scene and that you travel more than 25 miles an hour above the speed limit. So, I mean, you're zooming by a police officer. Who should be surprised? I mean, this isn't an attenuated, like, oh my heavens, look what happened. There was a chase. Squad cars were damaged as a result of the chase. So what's wrong with restitution?
I think you have to look at the harm that could have resulted from the risk. In this case, the harm that could have resulted from Shears' risk is running into another vehicle traveling on the road that didn't know he was involved in a high-speed chase, maybe running into a pedestrian or other property. In this case, he did run over a fence. But within his scope of harm is not that a police officer would make the decision to run into him.
What about, Ms. Stewart, what about, I'm looking at Section 32 of the Restatement Third of Torts, and that says, if an actor's tortious conduct imperils another or the property of another, one could argue that Mr. Shears' conduct did that, the scope of the actor's liability includes any harm to a person, well, I guess this is property rather than a person, but I think there's some analogy, resulting from that person's efforts to aid or protect the imperiled person or property, so long as the harm arises from a risk that inheres in the effort to provide aid. Doesn't that kind of maybe get you part of the way there, maybe not all the way?
I don't agree. I believe that, again, you have to look at the harm that could have resulted from his risk. One of the harms that could have resulted is not the police officer's decision to run into him. They caused or precipitated their own risk by making that decision.
Let me give you another, let's move away from police officer, give you another hypothetical. I come home one day and I see somebody running out of my house with something that's super valuable, you know, I don't know, my pet cat, all right? So I give chase in my car, and the person drives faster and faster, and then I do the PIT maneuver, which I don't know how to do, but let's say I did know how to do it, and then I sue that person in tort. Would I be able to recover for the damage to my car?
No, it would fall outside of the scope of harm, or the scope of risk. The risk here was the stealing of the cat. There's no way that then what resulted, a car accident, would have come from stealing a cat. So again, it would be outside the scope.
Justice Mansfield brought up Restatement 32, but I want to bring up Restatement 33. And it has two provisions in there. It says an actor who intentionally causes harm is subject to liability for harm even if it was unlikely to occur. And then the next section says, an actor who intentionally or recklessly causes harm is subject to liability for a broader range of harm than the harms for which the actor would be liable if the actor only acted negligently. Why don't those apply in this case? I mean, you got the conduct of your client was either reckless or intentional conduct. He was intentionally running away from the police. He was driving recklessly at high speeds. So if you're going to apply tort law, why wouldn't we apply the proper restatement?
I believe the proper restatement is Restatement 29. And then if you go beyond that to Restatement 34, I think this would get to your question. There's an intervening act here. And any time there's an intervening act that is outside of the control of the offender, then he's not liable. And here, I want to reiterate that intervening act is the police officer's decision to perform the pit maneuver.
And if you're going to use negligence, I mean, in this action, don't we have to look at, because the statute says you're only liable as you would be in a civil case, and then do all the comparative fault come in, so the officer may be 10% or 20%, and the driver may be 80%, and as a court, if we're going to apply negligence standard, which you want to apply, do we have to apply all the comparative fault things? Because the statute says, as in a civil case. And in a civil case, if it is negligence, we do apply comparative fault. So do we have to have a judge make that weighing if we're going to follow the statute, as you say?
I don't think so. All you have to do is use the scope of liability and determine if, based on his tortious conduct, if the harm would have resulted. And that's an easy test under Restatement Third. And I believe that using that test, Mr. Shears would not be liable for the damage done to the
Are you,
Stewart?
Ms. Stewart, was the pit maneuver an unforeseeable intervening cause?
I think so, yes.
And discuss that. Why would it be unforeseeable?
As I mentioned earlier, Mr. Shears, the harm that could have resulted from his tortious conduct is running into someone else while he was eluding, or someone running into him unwittingly, not knowing that he was in a high-speed chase. And it's not the police officers running into him. Maybe if it had been the reverse.
Isn't it a sort of an accepted or standard protocol in some communities to utilize this maneuver? We're talking about it, we know about it.
It could be in some communities, but that doesn't mean that it's still within the scope of harm. The only harm that he could have assumed was, again, running into someone or property, which he did do. He ran over a fence, but the harm that the police officers suffered weren't within his risk standard or circle, if you will, for the scope of liability.
The statute says, could recover against the offender in a civil action out of the same facts or events. If this were a civil action, why don't we consider fault rather than just proximate cause, or legal? It's called legal cause now. Why don't we consider everything when you have a civil action?
Can you repeat that question? I'm not sure.
In a civil action, a jury would determine the fault on each side, comparing the act and the causation to each other, and it may not be 100%, and the statute says the same as a civil action. So why wouldn't we also consider the quality of the act by the defendant?
Well, maybe you would. We know that scope of liability is fact intensive. You compare all of those things, but scope of liability doesn't necessarily call for comparison.
But that's only causation. You're not talking about duty. And once you have, in civil liability, you have a duty and you have causation. And you have to look at both of those and then do a comparison.
Within scope of liability, you don't have to look at duty. Duty is taken out, and you literally just look at the tortious conduct and then all the harm that can result.
How does the statute take duty out when it says the same as a civil action?
Well, Thompson v. Kaczynski took duty out when it created scope of liability. And so when this court uses scope of liability to determine the harm, duty is not something that is a factor or needs to be considered.
Counsel, I wonder if you're viewing the risk that makes the conduct tortious too narrowly. I think you'd concede that if Mr. Shears had accidentally, during this eluding, crashed into another car, he'd be responsible, right?
I agree, yes.
What if the officer, instead of intentionally performing this maneuver, had accidentally sideswiped another car during the chase? Is that within the scope of Mr. Shears' liability?
Well, I believe it could be. It changes the facts, but here the facts are that it wasn't accidental. The police officers made a decision to ram into Mr. Shears, and that is the crux of scope of liability, which changes the liability.
But couldn't a fact finder find that given that it's police practice to try to bring a chase to an end, that would be within the scope of liability? Isn't that a question of fact?
I think it would be. My answer and my argument to that is you should look at the normal course of business that police officers utilize every day, and a pit maneuver would be within the normal course of business, which would, again, take it out of the risk of harm and out of Mr. Shears' scope.
Let me ask you about a case, the Bonsteller case. It's a conversion case, and the restitution question was whether an audit performed after the crime, the cost of an audit, was subject to restitution. We said yes, because it was directly caused by the crime. Well, it's kind of interesting because the audit itself occurred after the crime had been completed. It was done by third parties. It wasn't directly caused by the malfeasance. How do you deal with that case? Doesn't that suggest that this need for a tight, direct causation does not apply under restitution?
I believe that scope of liability should have been used in that case too. I'm not familiar with it. I'm basing it off of the description you provided. But if it's too attenuated from the risk, I do believe it's outside the scope.
So you're talking about attenuation, and this enterprise that we're engaged in is one in which we're deciding how far to go in making items of damage within the scope of restitution. Is your argument really sort of that if law enforcement intentionally rams a suspect in order to bring a stop, to effect a stop, that's sort of a cost of doing business for the state or the governmental entity involved, rather than something that should be a subject of restitution?
Yes, that's the stance I'm taking. They use their vehicle as equipment in the normal course of business to perform their duties, and Mr. Shears shouldn't be liable for that.
We probably could have some arguments about other kinds of equipment. Let's say Mr. Shears had exited his vehicle, and a couple of law enforcement officers chased him, and in the course of the chase, one of the officers tore his shirt. Would the cost of the shirt, replacing the shirt, be an item of restitution under your standard?
I don't believe so. I see my time is running out, if I may finish that thought. I don't believe so because, again, it's attenuated and it's not a harm that results from the risk that was taken. And so for those reasons and the reasons stated in the brief, we ask that you vacate Mr. Shears' restitution order. Thank you.
Ms. Stewart, thank you as well. Ms. Huser.
May it please the court, counsel. My name is Kelli Huser, and I represent the state of Iowa in this appeal. The standard we apply in this case is proximate cause because the legislature has not changed the statute to suggest that it wanted to adopt the restatement third.
Yeah, but it says apply tort standards, so, right? Apply the law that would apply if a private person were suing. So if that law evolves as part of the common law, doesn't the restitution standard evolve?
I disagree. I think we take a step back from the statute. We're talking about two definitions here. The definition you mentioned is the definition of pecuniary damages, which I would suggest is a type of damage. We look at pecuniary damages, all damages to an extent not paid, et cetera, except certain types of damages, punitive damages, damages for pain. The language this court is interpreting, or has interpreted actually, is in victim, means a person who has suffered pecuniary damages, which takes you to the type of damage, as a result of the offender's criminal activities. As a result of is the causation language that this court has interpreted as the proximate cause standard. And because the legislature has not acted to suggest scope of liability applies, proximate cause is the standard this court should consider. I suggest that under either standard, these damages are recoverable.
Let me ask you about the firefighters rule. Does that have applicability? I mean, that limits the ability to which firefighters and police can bring civil actions against perpetrators or of situations that they have to respond to. Does that have any applicability here?
I'm not familiar. Is that just a common law rule?
A common law rule we follow here in Iowa.
Yeah, I would suggest, to the extent that's a type of damage, the firefighter is a type of damage, yes. Would that be recoverable as a type of damage? Yes. But as far as causation principles, that's a different question. And I think it's important to distinguish between those two definitions because otherwise, really the statute has two different causation standards. There's the as a result of in the definition of victim, and then a separate causation standard in pecuniary damages. And I would suggest legislature did not intend for the statute to ebb and flow with changes in our civil law other than the types of damage recoverable. The Bonstetter case, I would suggest, was a type of damage case. The example was in a conversion case, a civil conversion case. Could you recover the cost of litigation? Well, no, not generally. But conversion had an exception for audits.
All right, so let's play off that concept, and I want to give you the following hypothetical. The facts are exactly as in this case, but no criminal charges are brought. for whatever reason, the county attorney elects not to bring a charge. But the city of Davenport wants to bring a civil action to collect the damage that was caused to the police car. Can they bring such a civil action? What would it look like? What would the cause of action be?
I believe it would be a car accident type of action.
What's the cause of action? Is it a negligence claim? Is it a products liability claim? Is it a strict liability? We lawyers have these categories that we put tort claims in. What kind of claim would the city have absent the criminal process against Shears?
That I am not sure of. Certainly his action was.
I'm not sure of it either, frankly. And if you can't bring a civil claim, I mean, we need to think this through, and I'm not sure where it leads either. But if there was not a civil cause of action to collect, unlike in all these other cases, when the defendant smashes into the car, you would have a common law cause of action for the damages and so forth. But here, I'm not sure you would. And if not, doesn't the definition, which says which a victim could recover against the offender in a civil action arising out of the same facts, I mean, doesn't it kind of take you out of the statute?
I don't think so, because again, I think we're talking about a type of damage that could be, not would be, but could be. Could we bring some type of cause of action in this case in a civil realm? Yes.
But you couldn't in a civil realm because the fireman rule would preclude recovery.
But again, I think I think we're confusing the two causation standards that we're talking about. This is not, if the legislature had intended for this court to only for us to only seek damages that could be recovered in this, as the civil action, the statute would just say a victim is a person who can recover any damages under the same facts in a civil action. That's not what it says. It says as a result of the defendant's criminal activities.
The counsel, the fireman's rule, there's cases that say it does not apply to an intentional tort. So was what Shears, the conduct he was engaged in, an intentional tort or merely negligent when he's trying to elude police on a high-speed chase?
I think we could argue that it's an intentional tort, and
He
thus would
intentionally
apply.
plow into the police? I mean, is there evidence of that in the record? There may be. Did he intentionally, like in Dillon, one of the cases that's cited here, if I read the facts right, I mean, the party charged intentionally rammed the police. That would be an intentional act. But is there any evidence here in the record that the eluding was intentional, I take it, but was the damage caused to the police cars intentionally caused by the defendant?
Yes, I think the defendant's intentional actions and his choices in eluding and all of the facts together, actions have consequences, and his actions here led to a police response. And a police response in these types of fact patterns is foreseeable under the proximate cause standard and is also within the scope of the risks that the defendant should anticipate. To your Honor's comment about intervening cause, that is kind of the tort concept of when does another person's actions take us out of the realm of causation where it breaks the causal chain. And this court's case law under both standards, proximate cause and scope of liability, under both standards, this is recoverable. In Mitchell, which was the scope of liability standard, risk posed by even an extraordinary force of nature or by a culpable human act may be precisely the risk that render tortious the actor's actions. And so I understand this thought of, well, does it feel unfair? No, not under this statute. It's not unfair for a defendant who eludes 7 stop signs before they even deployed the spike strips. Stop sign 8, 5 red lights, almost hits another car, drives into oncoming traffic. His passenger jumps out of the car. All of that happens, well, the woman stepping back, but he's going 80 miles per hour in a residential area before we even attempt the first pit maneuver.
Let me run another idea up the flagpole, if I might. In the in the area of OWI, the OWI statute says, in effect, in addition to the restitution you can get under 910, for OWI you can also get restitution for the costs of the emergency response. Is that an implied statement that if the crime is not OWI, you can't get the cost of emergency response? And can one argue that what happened here was basically one version of the kind of emergency response that police make?
So I disagree because of the timing of the statutes. The legislature passed our general restitution statute in 1982 and then was able to address broad sweeping changes across OWI in the mid-90s. And so they had the opportunity, yes, at that point, to be more specific on the types of damage for this specific crime. But the legislature does not need to go through every single criminal law that we have and define what damages are recoverable. We have the general statute for that. So I don't think we can read into the OWI statute that there was an intent to exclude police response from our general restitution statute.
You don't think there was a recognition that it wasn't previously included? I mean, because that's the point. It's not so much was there an intent to exclude it, it's was there a recognition by adding that it must not have been previously covered, right?
If I'm remembering correctly, and I don't have this exact case in front of you, but if I'm remembering correctly, the legislature came in and added that specific language because there was a case that they said it's not recoverable because it's not more specific. And so I think that was a legislative response. I think.
Let me ask a related question. Who is the alluding? It's pretty clear, for example, if I shoot a police dog, I did find a case of restitution involved the shooting of a police dog, and the police dog, it was a willful injury to animal charge or some such thing. Police dog is dead. The police were the victim, and they collected for the dog. Fair enough. But in alluding, is it fair to say that the police are actually the victim when they're just kind of doing their job of trying to enforce the law?
Yes, under the definition of victim in our restitution statute as a result of the offender's criminal activities. And I would say I disagree with the idea that this was normal course of business. This was not normal course of business. I think foreseeability is a limiting principle when it comes to can the officer get, for example, salary in a particular case, or the example of the wear and tear on your uniform. I think that we would say, look, we're not seeking these normal course of business type things. This was not the normal course of business. Our police cars are not bumper cars on the streets. That is not their main purpose. Their purpose is to get from...
I don't know about that. I mean, police car is designed for high-speed chases, surely.
But not as their... I mean, it's not like...
Bumpers and extra souped-up engines and all that kind of stuff.
But it's not like the spike strip example from the Wisconsin cases where this primary purpose of a spike strip is for someone to run it over and it stops the car. It has one use, that's it. I think our citizens would not agree that the primary purpose of the cop car, the primary purpose is to travel from one location to another to investigate crime, to get to crime. It's a mode of transportation. Yes, it has additional accessories, we'll say, that would allow it to do additional things, but it's not normal course of business. And I do think another limiting principle is the idea that it does depend on the crime. If I'm going, 5 over on I-235, is there a pit maneuver there that I should expect that's foreseeable? I would suggest not. But this situation, where we have numerous stop signs, red lights, we're exceeding in a residential area 80 miles per hour, a woman jumps out of the car. I mean, I think in this scenario, yes, it's foreseeable that officers are going to try to stop you, especially when, before the pit maneuvers even happen, we've put out spike strips that the defendant swerved around. So he knew we were trying to stop him. This is not a fairness situation. It's not unfair to this defendant, because it is foreseeable that this was going to happen. Police action can be foreseeable. I want to touch on the comparative fault question. Now, the Court of Appeals has a published case from '92, and I understand it is not binding on this court, but I do think this court should consider that in 1992, it's the State versus Wagner, 484 Northwest 2nd, 212. The Court of Appeals said comparative fault principles do not apply to restitution for criminal acts under 910. And I think that's relevant because this court should consider that since 1992, the legislature has known that this published opinion says comparative fault principles don't apply. And I think that is something for this court to consider.
Is that because under our comparative, or under our tort law, you don't compare the fault, the negligence of the victim to an intentional tort? And what was the crime in Wagner? Was it something that would be an intentional tort?
I have notes about Wagner. I do not recall or have down the exact crime, but I do know they did talk about fraud and intentional torts are not included in the definition of fault. So yes, it was this. They specifically touched on fraud and intentional torts in that case.
What I'm told it involved a prison riot. So that
Oh
would be,
yes, it did.
Okay, so that and Justice Christensen gets credit for that.
I would say also that when this court considers the restitution statute, that it has purposes greater than just torts. This court has recognized in a footnote in Holmberg from 1989, this court's case, that there's a limitation to the analogy with tort law because there are different purposes. Not only are we trying to compensate the victim, but we also want to deter and rehabilitate the offender. And those purposes also indicate that this police action is the type of action that we should recover restitution for. Thank you.
Ms. Huser, thank you as well. Ms. Stewart, you may present your rebuttal.
I want to first talk about victim as defined in our statute. So I think it's important to point out that here the police officers weren't a passive victim. They made decisions. They made the decision to ram into the back of Mr. Shears, and that alone takes it out of Mr. Shears' scope of liability, which again is the standard we should be using. One of the reasons that we no longer, or Thompson v. Kaczynski no longer wanted to use proximate cause was because it was unfairly handed down or and not proportional, because with proximate cause you go all the way back. Most times the fact finder would go all the way back to the original action and call that the but-for cause. With scope of liability, it makes it a lot more clear that you should just be looking at the risks that result from the harm. And again, here the risk that Mr. Shears took was eluding, which was pointed out is a victimless crime. He didn't intentionally run into the police officers. Again, they made the decision to ram into him. And I want to also talk about, I believe an OWI case was referred to. Here, this is different. The OWI, the exclusion was not meant to include the police showing up at the scene and doing their duty, which is the same thing here. They showed up, or they rammed into the back of Mr. Shears in the normal course of business. It can be equated. You shouldn't be able to collect for things that the police do in the normal course of business. And here, just like with the spike strips, they use their vehicles as a means to stop Mr. Shears from eluding. And so for those reasons, Mr. Shears should not be liable.
Well,
His restitution
let me
should be
just ask
vacated.
you a question before you sit down.
Sure.
You know, we've been addressing this case by talking about all the legal doctrines and the civil principles that would help resolve what constitutes restitution. But what we haven't talked about is what really is going on here. And I see what's going on here is that the expanding nature of the costs and the fees and the fines and the restitution that's imposed on people when they go through our criminal justice system, and they come out burdened by all of these expenses, and they dig into a big hole that that they can never get out of, which is a very concerning for a justice system. But isn't the real problem here needs to be addressed across the street and not by the civil principles that we try to decide who's a victim and how compensation to victims should be determined?
I agree
I mean,
that,
are you asking us to do more than what we can do?
well, today I'm just asking you to vacate Mr. Shears' restitution order, but I agree with you that, that there needs to be something that determines where we draw the line for when a police officer or government entity who's acting in their duties can collect restitution. Do we draw the line, as the example before, their shirt rips and they have to take it to the cleaners to repair? Do we draw the line when they use their vehicle as a means to perform their duties? I'm not sure of the answer to that, but in this case, I believe a line should be drawn that Mr. Shears does not owe for the damages done to the Davenport police vehicles because it was outside the scope.
Ms. Stewart, thank you.
Thank you.
The case of State versus Shears is now then submitted. We'll next hear the arguments in Cox versus Iowa Department of Human Services.